Hey everybody, welcome back to another weekly edition of TuckerAllen Facebook Live, where we take about 15 minutes out of your day and discuss a small estate topic. This week we're going to be talking about oral estate agreements, and we've got our attorney from the Independence, Kansas City area with us, Kevin Mason. How you doing, Kevin?
Good. Thank you for having me today, Jim.
No problem. And I'm Jim Gau. I'll be your moderator. I'm a TuckerAllen attorney in the St. Louis metro area. And just before we get started, I want to do a little disclaimer. Remember to visit TuckerAllen.com to get more information on us, our attorneys, and the services we provide our clients. You can call 866-335-3375 to get in touch with us and make an appointment. And just remember that the choice of a lawyer is an important decision and shouldn't be based solely on advertisements. This Facebook Live does not constitute an attorney-client privilege or create an attorney-client privilege in any way. You'll have to set up an attorney meeting with one of us to get that started. So, Kevin, let's dive right into the oral estate agreements.
Sure. So, I can't remember, maybe correct me on this, but I know that it's an incredibly high number of people that die intestate. So what I mean by intestate is just that they don't have a will, they have no estate plan in place. There's really nothing to determine where their assets are going. So even though, they may have said at times these were my intentions, there's really nothing written down anywhere that would constitute a legal document in any way showing what their intentions are. And a lot of times in these situations, their heirs start coming in and saying, well, they told me that they intended me to get this piece of property or this car, or, they wanted me to have the money from their bank account, whatever it is. They make assertions, saying that this was supposed to be mine. This is what this person intended. They told me so. And those things are just very difficult to enforce.
Right. It's almost a he said, she said, and one of the he says or she says is dead. So
right.
It's so I guess walk me through what is an oral estate agreement? What are we talking about when we're saying that word?
Sure. So what we're talking about is it's very similar to like an oral contract where two people enter into a contract, they shake hands and they say, this is what we want done. And courts do at times, they honor oral contracts. And the way that they do that is they look to how the parties act. So they say, okay, if these guys had a handshake agreement that, one of them would provide this service in exchange for this amount of money, and then that one, pulled this amount of money out of their bank account to pay for it, and the other one started, their work completing the service, then a lot of times the courts will say, yes, there was an oral contract that was formed here, and we're going to honor that, force the parties to honor it as well. So an oral estate agreement is similar in the sense that, it's two people that are entering into an agreement where one of them is saying, I want you to have, my farm whenever I pass away. The difference here is that's a little bit tougher, right? Because one of these people, like you had just said, is deceased. Mm-hmm. So it's kind of hard to ask. There's no questions that you can ask them. But the court will at times, they'll still try to look back and say, okay, there is some evidence here that both parties were acting in a fashion that would make us believe that there was this oral estate agreement.
So something like, so I know, estate planning documents, you said oral contract, which isn't necessarily an estate document, but mm-hmm. we've got wills and trusts. Now, wills are going to need to be notarized and witnessed and stuff like that to be valid. But so you're saying we could probably do an oral trust so long as there was a showing that, this property was transferred to be held in trust. So if they did a little bit, something in furtherance of that oral trust, then possibly the court.
Yes, they would have to do, and a good example, I think, would be maybe, let's say, like what you were just talking about, and somebody had said, oh, I want this person to have my farm. And then they can show, after we have, maybe there was an exchange somewhere that was written down, text messages, emails, something to show, relating back to this oral exchange. And then they can show, hey, I've spent the last decade working on this farm, learning the intricacies of this particular farm, learning how to farm whatever it is that they're farming or use it to its fullest capacity. And, potentially if you could show all of those things, then there is a chance that the court would honor that. But, all of this is not in the hands of the heir or the deceased person at that point.
Right. And everybody comes into our office and says, well, our main goal is to avoid probate. Well, imagine the nightmare of arguing this oral contract. So,
Right. Yeah. This would be even more painful than just a normal probate situation, because there's nothing, I mean, you're trying to argue about an oral agreement, and one of the people of the agreement has passed away. So it's,
right.
I mean, the probate on this would be, I think, even more would obviously be more painful and more expensive than a normal probate even.
Right. So I think it's probably safe to say this doesn't work in all situations. This shouldn't be somebody's go-to estate plan, is to do it orally.
No, absolutely not. So they're right. All of this is to say there might be situations where this possibly could work. This absolutely isn't the best method. And there's absolutely places where it's just flat out not going to work. So, courts will still enforce, or they may enforce, an oral estate agreement, but they aren't going to enforce one that's unlawful. So, like, maybe going back a little bit to the contract analogy here. So courts, they also will not enforce a oral contract that is unlawful. So some contracts have to be in writing. Some things with an estate plan must be in writing. So like a guardian for a minor child, that has to be in a legal document. There's no way to say, well, this minor child's mom, she had told us that if anything ever happened to her, that she would want us to take care of her child. That's just never going to fly. That's unlawful. The court will never accept that. Something like that would absolutely have to be in writing. So that would be one of the examples.
Okay. Yeah. So since we've kind of fleshed out that these oral agreements are not the best way to do things. So how can someone, comes into your office and sits down with you, how can they for sure avoid a situation where their estate beneficiaries are, up to a decision to be made by the court?
Sure. So I think the best way to do it is you got to get some sort of estate plan. If somebody walked into your office and was talking to you and was saying, "Oh, my kids know what to do," because I'm sure I hear that pretty often, and I'm guessing you do too. With maybe they have a trust, right? And they're like, "Oh, we have this one beneficiary that maybe isn't sure what's going on quite as much as the others, but my other children are going to take care of them." And it's like, that's not the way to do that. So very similar, if somebody ever said to me like, "Oh no, I told my kids what to do," I said, "No, that's not, my job here is to work in your best interest, and that's not in your best interest." So my suggestion is going to be, let's get an estate plan in place. Whether it be trust-based or will-based, we need to get something that's down on paper, that's a legal document, that's been signed, been notarized. If it needs to, it's been witnessed. So that's just far and away the better path.
Yeah, and you even brought up something interesting, the fact that someone could have something in writing, but their actual intentions, they're kind of merging this. We've got a writing plan, we've got a plan written down, but we also have an oral agreement with two of our kids to take care of a third one, and just write it in the trust, because the rule of the court is, if it's in the four corners of the trust, that's what they're going to go by. They go by what the document says. So yeah, don't mix oral and written either.
No, people do. They like to do that, to say, "Oh, I don't want to make this confusing or more burdensome." I'm not sure exactly all the times what their rationales are, because it's not, it's our job. If it's more work for us, who cares? That's our job. But it doesn't make any sense to me to say, I have this agreement with my other children. Like, let's get it in the trust, because there's no way to enforce it if it's not there. Then it's up to the generosity of these other children, and there's family dynamics that can come into play, and situations change. So always better off, let's get it in writing.
Yeah, absolutely. And I'm sure you've seen this, and we see it all the time. And some of the viewers here probably think this way and have it set up this way, that we've got $50,000 in our checking and savings account. We're just going to put one of our kids as the beneficiary, and they'll divide it up between the other ones. Well, not only is that kind of an oral agreement, and technically it's just that one child's money when you die because they're the beneficiary, but it's also a bad, now this other they inherited it all, and now they've got to make taxable potentially gifts to the other kids. So it's beyond just not being enforceable. Even if it goes through the way they want it to, it's not necessarily the best thing for them.
No, absolutely not. And just putting it down on paper really eliminates any of those potentials for things to, go wrong or we see it often. Families can be messy, right? Every family has something going on in it that's not perfect.
Mhm.
And why do we want to create something that can potentially exacerbate some sort of issue and make it even messier? That doesn't
Yep.
make any sense whatsoever. Like, let's do our best to preserve the family harmony here. And the
Right.
best way to do that is to just put it on paper. So,
Yep. And I've seen families fight over things as silly as the blue vase in the house entry hallway. So saying that I'm sure they'll just divide the money up between them peacefully is kind of maybe a little bit out of the realm of possibilities.
right. It's a bit of a stretch to say, like, once we start dealing with money here, that people are going to be just happy doing as they were told by somebody who's now deceased. So things change a lot whenever someone dies, I think we can both attest to. And, another thing that I hear people say all the time, which I don't know if you do, but they always say, like, oh, I don't need an estate plan, or I don't have an estate plan, or something like that. And I always kind of think whenever they say it, it's like, well, you actually do have an estate plan. It's just that the state is the one that has created your estate plan.
Exactly. Yeah. The statutes of the state of whatever state you live in. Yeah, they've written a default one for you. And a lot of the
Mhm.
times it's not what everybody wants, because it's not just a simple everything goes to my spouse. It's like half and a half to the spouse and kids most times. So
Right, or it can be
um
two-thirds, one-third, or
yeah.
you can end up in a weird situation where a minor child might own like a portion of a home
Yep.
or something. Yeah. So it's whenever people are saying that, it's like, oh no, I told people what to do. I don't need an estate plan. It's like, well, you already got one, and it's probably not the one that you want. So
Yep.
then you're putting it kind of on the court to do as you would hope that they would do, which is just not going to happen most of the time.
Yep. Yeah. Well, I think that pretty much sums it up. Don't do oral estate plans. Don't rely on them. Get into a Tucker Allen attorney. You can schedule appointments with us at TuckerAllen.com. We've got our calendars right there, whether it be in the Kansas City area or the St. Louis area. We can do virtual or in-person appointments. Explain everything to you, get you all set up. But yeah, it's definitely, if you're relying on the kindness of your kids to share your money, or an oral agreement with somebody else to distribute your assets, maybe it's best you come in and schedule a consultation with us for an hour or so.
Yep. Thank you so much, Jim.
Yeah, thanks for joining us, Kevin.